3, 2, 1, ready, start. It was also urged that the said decision does not consider the object of Chapter 5 of the Act of 2007 nor the scope of how a residence order, if claimed by a senior citizen parent, can be made effective and meaningful, especially in light of Rules 21 and 24 of the Rules of 2014. Moreover, it was pointed out that the division bench in Bipraji Singh (Supra) did not consider the decision of the apex court in S. Vanitha (Supra) and for the aforesaid reasons it cannot be pressed into service to deny a right of eviction, especially when the entire scheme of the Act was not considered in the correct perspective in the said decision. It was lastly urged that the later division bench decision of this court in Shivani Burma (Supra) noticed the entire scheme of the Act and the rules, including the word maintenance, which includes the right of residence. It also noticed the impact and import of the decision of the apex court in S. Vanitha (Supra) and thus, after taking an overall view, it has rightly concluded that to provide the right of residence maintenance to the senior citizen parent, if an order of eviction is required, then the same can be validly passed. Submissions on behalf of the State of UP. Sri Nishant Shukla, Learned Standing Counsel for the State, has provided a copy of the Comprehensive Action Plan framed by the Ministry of Social Welfare of the State of UP, for the record and has referred to various provisions of the Act of 2007 and the Rules of 2014 to submit that the schemes of the Act is such that it recognizes the dual need of maintenance and protection of senior citizens parents, and it also includes the element of avoidance of harassment for such class. It emphasizes that in order to avoid harassment of a senior citizen parent and to provide meaningful maintenance and protection to a senior citizen parent for their dignified living, an order of eviction, if required in a befitting case, it can be ordered by the tribunal as well as the district magistrate as explained by a division bench of this court in Shivani Burma (Supra) It is urged that while the district magistrate, in order to protect a senior citizen or his property, apart from resolving any dispute relating to maintenance, or in the case where a right of uses of such property of the senior citizen oblique parent is involved, then in order to provide the necessary relief to such parent oblique the senior citizen, comma, an order of eviction can be passed, and this would be a power implicit with the maintenance tribunal and district magistrate as the case may be. It has further been submitted that the apex court in S. Vanitha bracket supra bracket close had recognized the power of the tribunal to pass an eviction order in compelling circumstances, and the only caveat which is required to be exercised is that the tribunal or the district magistrate, comma, as the case may be, must be satisfied and must record reasons relating to the existence of compelling circumstances which requires passing of such an order by recording its satisfaction, that in case if such an order is not passed, then it would deprive the senior citizen of his right to enjoy his property with dignity and peace. Stop. It was also submitted that Section 23 of the Act of 2007 clearly recognizes the power vested with the tribunal to declare a document of transfer executed by a senior citizen as void, and this also reflects the pervasive power conferred on the tribunal, comma, then, comma, as a concomitant, the tribunal can pass even an order to restore possession, including to evict a person, comma, failing which the tribunal will fall short of its obligation to provide a complete relief and benefit to the senior citizen oblique parent under the Act of 2007. Stop. Any other meaning ascribed would amount to defeating the object of the Act of 2007, comma, which would not be justified in law. Stop. Hence, comma, it cannot be said that the maintenance tribunal or the district magistrate, comma, as the case may be, comma, is not empowered to order eviction of the children oblique relative under the Act of 2007. Stop. Para. Submissions on behalf of the Union of India. Sri Sudhanshu Chauhan, comma, Learned Counsel, appearing for the Union, has submitted that even prior to the promulgation of the Act of 2007, comma, there were certain acts and provisions in law for providing maintenance to parents, namely the Hindu Adoption and Maintenance Act 1956 bracket hereinafter referred to as the Act of 1956 bracket close, and in the Criminal Procedure Code, comma, the provisions for maintenance is provided under Section 125 CRPC, which also finds reflection in Section 144 of the Bharatiya Nagarik Suraksha Sanhita bracket hereinafter referred to as the BNSS bracket close, which are of general nature and not confined to parents or senior citizens alone.